Good afternoon. First of all, thanks to the organizers for having me here, and thank you all for being here. My name is Bartłomiej Kucharzyk. I'm a doctoral student here in the Department for the Philosophy of Law and Legal Ethics, and also in the Institute of Psychology, also here in Kraków. And the topic of my talk reads, do lawyers think of white bears? I will explain it later. Inadmissible evidence effect in law students and professionals. Actually, it's a kind of report from my research. But let's start with the term inadmissible evidence. I know there are lawyers here, so forgive me for this short introduction. To put it simply, inadmissible evidence is all information that may not be used in a judicial trial, deciding the case by the judge. Let's see the rule 402 from the Federal Rules of Evidence. It's, of course, American law. It states that relevant evidence is admissible always unless any of the following provides otherwise. So there are some exceptions on admissibility of evidence. And let's see one example concerning hearsay. I suppose you know what hearsay is, but again, to put it simply, we want in a trial, we want to know where John was when the murder was committed, and we ask a person, "Do you know where John was?" And he says, "I haven't seen him, but someone told me that he was abroad or somewhere else." That's hearsay. That's inadmissible in the criminal cases in the United States. That's the rule against hearsay. Here's the definition of the hearsay, and it's just an example of inadmissible evidence according to the Federal Rules of Evidence. And how does it work? There is a general rule preventing the jury from hearing inadmissible evidence, but it says, to the extent practicable, the court must conduct a jury trial so that inadmissible evidence is not suggested to the jury by any means. But sometimes it happens that in some inadmissible evidence just finds its way before the jury, and now probably one of the parties will run an objection, but the judge has to instruct the jury to disregard the inadmissible evidence they just heard. It's not that easy, actually. There is plenty of research on that matter, and now I may explain what inadmissible evidence effect is. Let's see the Sewell-Smith-Caldwell study from 1973. They had three groups of students, actually, and they gave them a description of a criminal case. The control group was given a description with some clues on the guilt of the accused person. The evidence group was given some strong evidence. Actually, it was kind of bug, telephone tapping in that case, that it was quite clear from the recording that the accused was guilty. And the third group was given the same evidence, but on the basis of some procedural law or some aspects of the case. The judge in the case ruled that evidence inadmissible. They were forbidden to use it in deciding the case. And what they did was, control group, almost or no convictions at all, just the clues they were given to them. evidence group like 25 or maybe a little bit more % of convictions. And in inadmissible group, it was like even more, 35% of convictions. That means that the prohibition or the instruction to ignore the inadmissible evidence didn't work. The judges, the jurors, or the mock jurors, actually, the students who were playing jurors, they just ignored the instruction to ignore inadmissible evidence. And many of the studies later just confirmed this, this first study. There is a meta-analysis by Nancy Stedley and her colleagues from 2006. I think it was like 30 or almost 40 experiments on that. But there were some exceptions. Sometimes the mock jurors were able to disregard inadmissible evidence. A few examples. First of all, if the jurors, so-called jurors, were given other strong evidence, they were able to disregard inadmissible evidence. Another one, if the jurors were instructed to, they were obviously instructed to disregard evidence, they didn't, but if they were just told that the evidence is illegal or inadmissible, they did. Another one, inadmissible evidence conclusion. If the evidence suggests the guilt of the accused person, it's easier to disregard it than if it suggests the innocency of the person. Type of crime. It's easier to disregard inadmissible evidence if the crime is really serious. Deliberation. If we allow our subjects to have a talk with each other, they tend to disregard inadmissible evidence. And the last thing, justification. If we just give some reasons to disregard inadmissible evidence, it's easier to do it. There are, of course, some explanations why, in general, it's hard to disregard inadmissible evidence. I think the last two are most interesting. The reactance theory of Jack Brem. It's to put it simply, people tend to don't like when they are told explicitly to do something. Most of people just have some kind of resistance against orders, and that may be the case here. And the other theory by Daniel Wegner, the theory of ironic processes of mental control. Wegner claims that if our mind is occupied with some difficult task, it's sometimes hard to. Let's have an example. I think you know it. Just try not to think of white bears for a while. Is that easy? I know that's just an illustration, but that's the Wegner's theory is about in general. And that's hence the title of my talk. Because the question is, do lawyers think of white bears? In the United States, juries consist of lay people. And in Poland, as most of you know, we have no code on evidence of evidence. The evidentiary prohibitions in Polish criminal procedure code are quite sparse, and the verdicts are given by professional judges, mostly, who are lawyers, of course, and rarely they are helped by semi-professional jurors. But the statistics I know is that 1 of 100 criminal cases in Poland is supported by jurors, so not that much. Here is an example of Polish evidentiary prohibition from Polish criminal procedural code. If a person entitled to refuse to give testimony or exempted pursuant to Article 185 declares his wish and intention to avail himself of this right no later than the commencement of his testimony at the trial before a court of the first instance, any testimony previously given by him cannot be used as evidence or reproduced. I will show you an example of the use of this article, but how does it work in Poland? An evidentiary motion by one of the parties, for example, by public prosecutor or by the defense attorney, shall be denied when the taking of such evidence is inadmissible, for example, because of this article or other one. And the court shall base its judgment solely on facts and evidence disclosed at the main trial. So even if the judge knows the information included in the inadmissible evidence, he is forbidden to use it. Okay, and now do lawyers think of white bears, or precisely do lawyers ignore inadmissible evidence? Because in Poland this question is much more interesting than the do people ignore inadmissible evidence. Here's the material from my experiment. Please, all the participants were given this kind of instruction. Please read the following description of a robbery and murder. While reading, imagine that you are a judge in the case and your task is to decide whether the accused is guilty on the basis of the evidence presented. And now, all the participants were given some clues, some circumstantial evidence of guilt of the accused person. But one specific group was given a strong evidence of guilt, just the testimony of the brother of the accused, who claimed that his brother confessed guilt to him and was able to recall in details the dialogue between the murderer and the victim, which was known because of the testimony of some shopkeeper employee. And in the third group, because there was one control group, of course, which was given neither this or this. In the third group, there was the same testimony by the brother, but given during the investigation, so before the case was in the court. And then the same brother exercised his right to refuse to testify. And that means, according to the regulation we've seen a little bit earlier, that means that the court, it's forbidden to use that previous investigation testimony deciding the case. And I used those materials in 2 experiments. First of them involved 75 subjects, 30 law students, and it was designed. It was a little bit more complicated because I also investigated the cognitive control, but for our purpose, it's fine like that. 3 groups, of course: control with some circumstantial evidence, group of evidence, the same circumstantial evidence plus a strong evidence of guilt, and the last group with the same evidence but prohibited. The most important dependent variable is verdict, just guilty or not guilty. And here are the results. That's the result for all the subjects. So there is inadmissible evidence effect. Some convictions in control group, like 50% convictions in evidence group, and the same in inadmissible evidence group. It's almost, it's significant, but that's not important here. But there was no effect in law students. First of all, they convicted less likely than other students. And because of that, the results are inconclusive. There is no significant difference between control group of law students and evidence group of law students. That means that the evidence, even if it's admissible, doesn't work here or didn't work here. That's why I designed the second experiment. But this time the subjects were law students, first-year law students, and lawyers. Not judges. Some of them were judges, probably. But all of them were lawyers after they graduated from law school. Again, 3 groups, the same. And again, the most important dependent variable is verdict, guilty or not guilty. And here are the results. It's a little bit more complicated, but let's look at the students' results for a while. Some convictions in control group, more in evidence group. That means that the evidence did work this time. And a little less convictions in inadmissible evidence group. I think that some of those students from this group were able to disregard this inadmissible evidence, and some of them were not. That's quite interesting. And if we take a look on lawyers' results, it's like, again, some convictions in the control group. Evidence works as well. There are more convictions in this group than in this group, but there are even less convictions in inadmissible group than in the control group. So, actually, the lawyers were able to disregard inadmissible evidence. They were even more than that. If they saw the inadmissible evidence, they reacted like the reactance theory would predict. They were even less eager to convict the accused. And am I talking too fast? Thank you. So that's time for a summary. I don't know if lawyers think of white bears, but it's possible that they may disregard inadmissible, prohibited evidence. Of course, there is a question why they do that. Is it because of their education or some kind of professional training? That's the interesting difference, because it suggests that even among first-year law students, there is some probability that they ignore inadmissible evidence. So it's not that easy to say why do lawyers ignore inadmissible evidence. And the plan for the next experiment is quite obvious. I would like to study professional judges if it's possible. So thank you for your attention, and I would be delighted if you had any questions.